Okay, next up is our directors panel, which is always a real highlight. And moderating this panel is someone who's been a part of every securities enforcement forum since we've started doing this in 2012. And that is Brad Bondi, who is a partner in Cahill's litigation department and chair of the firm's white collar and government investigations practice group. Brad has 2 decades of experience at the highest levels representing companies, boards, executives. He previously served as a member of the executive staff of the SEC as counsel to 2 commissioners for enforcement and regulatory rulemaking. Brad, thanks for moderating this panel, and look forward to hearing from you.
Thanks, Bruce. Well, that was a beautiful tribute to Judge Sporkin, who is a friend and was a titan of the bar. There'll never be anyone like Judge Sporkin, I think, again. Beautiful tribute. We'll start.
Hold on, let me just finish up with all the introductions.
Sorry.
Next up, Stephanie Avakian, who is the current director of enforcement at the SEC and was named co-director of enforcement back in June 2017 and became director in August of this year. She's previously a partner at Wilmer Cutler. Really an honor to have Stephanie with us today and in all these events. Really no better window into what the enforcement division is doing than to hear from Stephanie. So welcome, Stephanie.
Thanks, Bruce.
Our next panelist, Andrew Ceresney, is a partner at Debevoise and Plimpton and co-chair of the litigation department there. Andrew, of course, was director of enforcement from 2013 to 2017 and has previously been the keynote speaker at this event in both DC and in San Francisco. Earlier in his career, Andrew was an AUSA in the Southern District of New York. Great to have you here, Andrew.
Great to be here. Thanks, Bruce.
Bill McLucas is a partner at Wilmer Hale. He's chair of the firm's Securities department. He joined that firm after serving for 8 years as director of enforcement, the longest tenured director ever. Basically, if you don't know who Bill is, that may be your cue that you've logged into the wrong conference. Bill, great to have you with us.
Thank you, Bruce.
Steve Peikin will be, as of next week, a partner at Sullivan & Cromwell in New York. From 2017 until August 2020, Steve served along with Stephanie as co-director of the Division of Enforcement. Before that, he was an assistant U.S. attorney in the Southern District of New York and also a partner at Sullivan & Cromwell previously. Steve, welcome almost back to private practice.
Couple more days. Thank you, Bruce.
Linda Thomsen is our next panel. She was the first woman to serve as a director of the Division of Enforcement at the SEC. Of course, she's now with Davis Polk. Linda returned to Davis Polk in 2009 after 14 years of public service at the SEC. While director, she led cases including the Enron investigation, stock options backdating cases, and many more cases. Welcome, Linda.
Thank you. Glad to be here.
Finally, Dick Walker is a partner at King & Spalding. He joined that firm after almost 14 years as global general counsel for Deutsche Bank. Previously, of course, Dick served as the director of the Division of Enforcement and as general counsel of the SEC, the only person ever to have served the SEC as both enforcement director and general counsel. Dick, welcome. Great to have you here.
Thanks, Bruce. Nice to be with our panel.
Thanks. Okay, I'm very pleased to turn over to Brad.
Terrific. Thank you, Bruce. As is usual, we will start off with questions to the current director of enforcement, Stephanie Avakian. Stephanie, you've been at the SEC for a while now, and as director, both with Steve Peikin and now on your own for a little while. What would you say has been your biggest lesson learned since being director?
Well, thanks, Brad. Thanks for doing this and for having me. Before I get started, let me give my standard disclaimer that the remarks I give today are my own and do not necessarily reflect the views of the commission or the commission staff. So, I mean, I've learned tons of lessons in this job, including, probably first and foremost about managing people and a large organization. But I would say, when I think about like the biggest lesson, or at least the lesson that's reinforced every day in this job, I think, is really don't let the noise get to you. I think in this job I found, and Steve and I together found, you have to do what you think is right for the right reasons all the time, and not get distracted by the noise, whether it's the press, whether it's the industry, whether it's the bar, whether it's the views of a single commissioner. But whatever it is, you've got to, I think, always take a step back and think about what's the right call here on the facts, on the law, on the policy. Our actions have very serious consequences, both for the people involved, potentially for the market, potentially for our own programmatic, reputation. And I think you've got to always step back and put that first and foremost. I think that's the lesson probably that I found came up every single day.
And Stephanie, what would you say is going to be your lasting impact as the Director of Enforcement?
I have no idea, Brad, but I think I could say it probably depends who you ask. I think I can say, look, structurally, and I won't speak for Steve, but I'd say structurally, some things we did together that I think will have lasting impact and real value in years to come were, creating the cyber unit, really focusing in on the whistleblower program in the last 18 months or so, and really putting efficiencies in there that have substantially changed the speed with which we make awards. I think a real focus on the distributions program, and including most recently, rolling out a new unit devoted to distributions, bankruptcy, receivership, and collections, which I think will really maximize results for investors. But ultimately, it's all going to be in the eye of who you ask. I hope that a lasting impact that I've had and that we've had together, I hope will be, the sort of how we approached the job, how we interacted with our staff. I think, some of the lessons we've tried to bring to bear on how to get it done quickly, how to resolve matters, how to negotiate in a way that gets us, to the end game faster. Those are things I think that are more intangible that Steve and I spent a lot of time focusing on. But I hope people ultimately come away and say, during their tenure, they told us over and over, take a step back and do what you think is right, make the recommendation you think is right. I hope that's what people take away.
Terrific. And this has been an unusual year in many respects. Probably the biggest has been COVID and the remote working environment for the SEC. Could you tell the audience a bit about how the SEC has adapted, how things are working now really in COVID, and whether or not there are going to be any lasting changes as a result? Will we see video testimony being used more often now in the future, even post-COVID?
It's a great question. In terms of where we are now, so the whole agency, like most people, we've been on telework since mid-March. We'll continue to be on telework for the foreseeable future, at least in the short term. And, it's really changed the way we've done business. It took a while to figure it out, I think, but, we're doing remote testimony, remote Wells meetings. We've done a remote trial. There's sort of nothing that can't be done remotely at this point. Obviously, in-person activity is preferred in a lot of circumstances, but we've kind of figured out how to do it. I think the folks here from the Defense Bar probably have a better sense, or at least some different sense of how successful it's been. But I do think figuring out how to do everything remotely has been a partnership with the bar. I think we've all tried on both sides to really work together to figure out how to get stuff done. In terms of what, are there going to be changes long term? I really don't know. Panels like this, they're 1,000 times easier to do, right? None of us have to travel, but it takes, not being in person detracts from the experience in some ways, not on the substance necessarily, but certainly in the human connection. I'd be surprised if remote interviews, lasted long term. I think there's a real benefit to doing those in person. The Wells meetings and stuff, they've been 1,000 times easier to schedule. I feel like we have done way more of those kinds of meetings on much shorter timeframes because it's easier to get people on the line together. I think they've been just as effective, but, I could see people taking different views on that.
Have you seen the SEC be hindered in doing its job as a result of COVID, or have you been able to work through everything in terms of working remotely, or would you say it's been hindered in any way?
I don't think it's been hindered given where we are right now. I think at the outset, look, if you think back, it's hard to put our minds back into March and April, I think. But back in March and April, all of us, I think on both sides of this, kind of thought this was going to be 2 weeks, 3 weeks, 4 weeks, kept pushing stuff out. And I think there was a time period where things slowed naturally because we were all trying to figure out, okay, what's the next step here? I think once everyone sort of focused on how are we doing this remotely? How are we issuing subpoenas? How are we checking our mail? How are, all those things. I think we've been very effective. And I think, we'll talk more about our response to COVID, sort of the investor related response to COVID, probably as this program goes on. But I think, if you look at how we quickly pivoted and took action in those circumstances, I think that really does underscore how we've been able to continue to be effective throughout this. But now I think we really are, sort of running as usual. We're just doing it all from a different location and in different ways. There are certainly some challenges. There are some, there are always special, circumstances or, things we have to solve for. But like I said, trials are back on. Stuff is moving.
And Stephanie, we always appreciate your advice to the defense bar in terms of how defense lawyers can be more effective at doing their job in presentations and Wells submissions. Is there any advice you have to the audience about how defense lawyers can be more effective in advocating for their client, resolving matters, and being more efficient?
I mean, I think I go back to, probably 2 years ago or so, Steve gave a speech on this issue. And I think the points in there are sort of as relevant now as they were then. And I focus most on sort of open communication. Both sides need to be thinking about what they hope to get out of this process, whether it's a pre-Wells process, whether it's a Wells process, whether it's even, post the start of litigation. But I think, figuring out what's attainable and what do you care about the most and coming in and being honest about that. I mean, it may be that you're swinging for the fences and there's a shot at making the case go away. It may be based on your interactions with us, you have or should have a good idea this case is not going away. And so let me think about how I can make it better for my client. How can I get to a resolution that both sides are satisfied with, whether that means fighting over a particular issue like materiality or scienter, or fighting over, I shouldn't say fighting over, but really working hard to focus the staff in on what is the thing I want to change most? What do I think I can realistically change? Is it a charge? Is it the financial package? Is it timeout? What is it? And let me focus on that as opposed to a strategy where you throw everything at us and say, I want everything. So that would be, I think, my greatest piece of advice. I try to be very open in these conversations, whether it's a Wells meeting or whatever, about what I care about, at least where I can. And I encourage folks to do that.
Stephanie, before we go to Steve to get his thoughts as his being your recent co-director, is there any other points you'd like to highlight for the audience about some of the accomplishments of this year?
No, I think our greatest look, we have lots of accomplishments, and we'll put out our annual report, I think, in the coming days or weeks. But what I look to most as the accomplishment of this past year specifically is how the staff dealt with and reacted to COVID-19. And it's on all levels. It's on everybody had their own personal stuff. We all had, kids who weren't in school. Many people had, became caregivers, had their own illnesses or problems. And so I think the fact that people absorbed all of that, and everyone did, the bar, everybody, but the fact that people had to absorb all of that but kept doing the job. We brought hundreds and hundreds of cases this past year. We got record financial penalties. Those aren't the things I point to as the most important, but the fact that we did those things in light of the substantial challenges people face, both personally and professionally, I think is the great story of 2020 for us.
Terrific. Thank you. Steve, you've recently left the SEC and will be heading back to Sullivan and Cromwell. We welcome you back to the private sector. In the past, you've emphasized the speed and efficiency of SEC investigations. I was struck by a remark you said that an SEC investigation shouldn't take as long as fighting a world war, which I agree with 100%. Do you see any particular things, though, Steve, that defense counsel may do to speed up an investigation and to avoid prolonging, the drawn out back and forth with staff?
Sure. I think that one of the things that, prolongs investigations is not just, deliberateness of the staff, but also defense counsel that, are slow walking responses. If you want to get the investigation done, the most effective thing you can do is produce the documents as swiftly as possible and not, re-inject privileged documents, 2 years after your production when you get around to making a privilege log. I think if you've responded swiftly and the staff is, in your view, conducting an overly protracted investigation, you have ammunition to escalate those issues and try to accelerate the timetable. The other thing is, there are investigations which I think after some sort of gestational period, both the staff and the defense lawyer, they may not agree on everything, but they know that there's a locus of facts or legal issues. And there isn't anything wrong with, if you believe this is a matter that is going to end in a resolution, with stepping forward and trying to propose such a resolution. Obviously, if it's a case or an investigation where you think, you're going to fight it or you're not going to resolve it, then that doesn't really apply. But many cases, I think everybody realizes that there are issues and can look at past fact patterns and see, where is this likely to land? You can bring an investigation to a conclusion. I've seen it when people come in and say, all right, we understand we have issues and let's talk about how we're going to get them wrapped up.
Steve, you were in private practice for quite a while before you became co-director of the Division of Enforcement. Now you're going back to private practice. Is there anything that you look back on from your days before you became enforcement director and said, if I only knew then what I know now, what would that be?
Sure, it's a great question, Brad. And one of the things, having never worked at the commission and never been inside the building, I didn't really have a good sense of, sort of how investigations progress and how the decision making in the division and with other policy divisions takes place. And now, I've thought back and thought to myself, is there something I know now that would have been of use then? But, working inside the building, and obviously, there are lots of people who are out in the world who have, really gives one insight. I think there are, frankly, some real advantages to having seen up close how decisions get made.
Now, Steve, I asked Stephanie the same question, which is what would she say her lasting impacts were as the director? We only have about 35 minutes left, so just keep in mind we don't have a whole lot of time. How would you answer that same question about your lasting impacts as director?
Yeah, you'll be shocked to hear I'm still in pretty violent agreement with Stephanie on everything. I don't know what my lasting impact. Hopefully, my name will be remembered, at least for a little while. I think Steph touched on a couple things which aren't really glamorous, but I think are actually really important. And that is, we put a tremendous amount of effort into rationalizing and increasing the efficiency of our distributions program, which is, evident in the huge amounts of money that have been returned to the pockets of investors over the last few years. Increasing the efficiency of the whistleblower program, which was originally designed, with the idea that there would be, 10 whistleblower claims a year instead of 4,000. And I think the increased efficiency and effectiveness of that is enduring. Managing the incredible avalanche of tips, complaints, and referrals that come in and make sure that those get eyeballed. Those things, those processes will outlive Stephanie and me. I'd like to think substantively that some of the focus we've put on trying to increase the effectiveness of our negotiation posture, how we bring things to a conclusion, I hope that some of that will endure. And then I know we'll talk a little bit about ICOs, and I think the framework that has been laid out and developed with CorpFin over the last few years, will have a lasting impact.
Terrific.
I would give all the credit for all that to Stephanie. I don't think my legacy is her.
Before we turn to some specific topics and before we get off completely on COVID, I thought I would go to Linda Thomsen. Linda, how have your experiences been in interacting with the SEC during this COVID time period? Are there areas where you think the SEC could be better? We may have a few more months of COVID, who knows? And are there any takeaways you have in terms of, as a defense counsel, about how to be more effective for your clients during this strange period of COVID?
Sure, Brad. First, I think it's fair to say, as with any answer any of us give on this, a lot of it, the answer is it depends. When you're dealing with some of the best at the SEC, and when you have defense counsel who are committed to doing their job well, I think it works incredibly smoothly. When you don't, when you have less than that on either side, it doesn't work so well or as well. But I think that's true pre-COVID as well. Wells meetings and meetings are I think, pretty straightforward. I think many of us miss in person, but they work very smoothly. I think there's a premium on preparation and a premium on perhaps having facilitating materials. And if you have facilitating materials, not reading them, there's nothing as dreadful as someone reading their script, if you will. But so I think, and on both sides, if there's preparation, it works well. There's a premium on brevity. I don't think any of these meetings go very well if they last more than an hour, and that takes getting prepped and focused, as both Steve and Stephanie said, up front. The hardest thing, I think, is testimony and trials. It's very difficult. It's very hard on the witnesses. It's very hard when you've got multiple locations that have to be accommodated. It's very hard with documents, which is not to say it can't be done, but I think it's not only less efficient, I'm not sure you're getting to the right result. As a consequence, I think people are looking to alternatives, proffers, interviews that are not testimony, which puts a little less pressure on the witnesses, because the technology for a witness is very, very difficult, I think. And as I said, a Zoom meeting, as we all know, that lasts an hour can be exhausting for everyone. Testimony that takes several hours remotely is just, I think, really tiring. So again, I think there's a premium on having the best staff and the best lawyers involved, because they can collectively come to a result that makes sense. The worst situations, at least that I've experienced, are when you have the less talented, less confident, less experienced staff who are sure that everyone on this call is out to bamboozle them, and therefore they're going to take the most aggressive stance. That makes life a little more difficult. But I think by and large, people have figured it out, are working hard to figure it out, and it's only going to get better. And I hope it's something we largely learn from, but then largely forget.
Anything you'd like to see continued post-COVID, Linda?
Well, as Stephanie suggested, I think all of us can get things done more quickly sometimes by doing things on video and remotely. It's not my favorite, but I think it works, and things work pretty quickly. I think thinking creatively about how to gather information, alternatives to testimony and whatnot, are things that probably should continue.
On August 31st, 2020, during the middle of COVID, the White House published an enforcement memo setting forth numerous safeguards that are recommended as best practices for government agencies to observe during regulatory investigations. First, I'll go to Stephanie and Steve. Has this memo impacted the SEC in any way and the way you conduct investigations? And have you noticed the enforcement bar, the defense bar, pointing to the memo saying, you're not doing what's in the memo?
I mean, I think, as you said, it's, identified a list of best practices. I think our practices are consistent with the best practices limited in the memo. I think as folks know, we've been very transparent about our practices. And so just by way of example, we've got the commission's rules relating to investigations. We publish our enforcement manual, which is, over 100 pages describing how we do things, is all online. We have a very thorough Wells process. We've got timelines, that come out of Dodd-Frank and the Exchange Act that we have to follow after issuing a Wells notice. So I think, for the most part, these are best practices that we follow. In terms of whether there's pushback from the bar and stuff, I think it's probably a little soon to tell. But I frankly wouldn't expect to see a ton. Steve, if you have other reactions.
Steve, anything to add to that?
No, I don't. I think the memo postdated my departure, so I'm probably not the right person to talk to it.
Yeah. Bill McLucas and Dick Walker, does this memo impact in any way your interactions with the SEC? Are you able to effectively use it and point to it in calls with the enforcement staff and the directors?
I haven't, and I wouldn't. I would make my arguments based on what I think the process ought to be. I would not point to this memo, certainly not at the staff level. My bet is, while it hasn't been stated here, the exception to this memo is that it applies to executive branch agencies and not independent agencies. And in any event, we really don't care. I think that the staff's view is we have a process that works. We do what we're supposed to be doing. Next issue. And I don't think it'd be effective to point to this memo and say, hey, you got to read this and do what the White House has suggested you do.
I agree with Bill. I think for the most part, the principles of fairness are things that people already argue in one shape or form. The statute's vague or ambiguous, and that should be, interpreted in our favor and against the government. There is one interesting item which says that basically when a party has attempted in good faith to comply with the law, which of course all of our clients do routinely in every matter, that needs to be part of the calculus of the public impact. And to the extent that may or may not affect the relatively low bar of the Tager and Wansover cases, I don't know. But I think for the most part, people have already incorporated all of these arguments regarding fairness within their presentations to the commission. So I don't see very much changing.
And Dick and Bill, as two of the more senior former enforcement directors, do you all have any views about whether the enforcement division needs to take up another Wells committee or to incorporate any safeguards? On prior panels, we've talked about a number of different issues, like resulting in too many ALJ actions and the seeming purported bias toward ALJ actions. The enforcement division seems to have addressed that. We don't see rumblings of that anymore. There have been issues about open jacket, and I think the openness of the enforcement staff has gotten substantially better in recent years. Is there anything lingering out there in your mind where you say, yeah, things need to be improved on this in terms of process or due process?
I would venture to say that the process has really improved, as you've pointed out, Brad. Over the years, it gets better. It's more transparent. There's better engagement. If there's one sort of lingering issue, I think it's sometimes the inconsistency. So, people are people, and some people that participate from the government side are sort of less forthcoming, maybe more combative. And those kinds of meetings and those kinds of presentations don't go as well as maybe when you're, in the presence of one of the directors, you're likely to get a lot of transparency, and the staff is probably going to be quite open. But look, I think that's a function of people, and that's always going to be the situation.
Bill, what do you think?
I would suggest would rise to the level of a commission or a committee. I mean, there's a fairly good level of dialogue between the bar and the staff. A little more of that on a more organized basis might be helpful. But, the reality is there's a chairman and there are 4 commissioners, and they have very strong views about a lot of things, including process. And our best capacity and efforts at representing clients on process type issues are really directed at the staff, and more likely more effective when they're done in a more straightforward, low-key fashion, not with some formal process where we're going to convene a committee and end up writing a report. I think the pain of that process is not worth the likely yield on the other side.
Mm-hmm. One of the big events this year was that the SEC litigated two key cases against Kick Interactive and Telegram, with the court in each instance finding that their initial coin offerings constituted securities under the famous Howey test. Steve Peikin, I know those occurred during your tenure as the enforcement director. How do these rulings in these cases impact the cryptocurrency market and the SEC's enforcement?
So, Brett, I think they're both pretty significant decisions. They're really the first two litigated matters in which judges opined on whether these offerings, which were different but had in common sort of a two-step process whereby there was an initial capital raise, including from accredited investors, and then in both instances, a follow-on contemplated distribution of tokens more broadly. And in both cases, although they're in slightly different procedural places, the courts found that the SEC's claims that they were one integrated offering that was not exempt from registration, that view prevailed. Look, I think it's going to have a very significant impact on future efforts to conduct ICOs through this sort of two-stage process. And I think that, practitioners are likely focusing on the decisions in both. And, I think they're going to be very, very difficult to do something in a form that looks like either one of those offerings without complying with the registration provisions or otherwise satisfying the availability of an exemption. Mm-hmm. And the cases were, well and hotly litigated by both sides, I think.
Steve, it's been reported that that there was quite a bit of interaction within the building between enforcement and Corp Fin. Could you shed some light on that interaction in the area of cryptocurrency, and is that a model for other areas?
So I think it was, during my tenure, it was probably the area in which there was the most interaction with Corp Fin. It's really hard to overstate how closely we worked with people in corporate finance, both in, figuring out what were the appropriate cases to pursue and also coming up with settlements, including settlements in which folks who had distributed tokens without complying with the registration provisions were able to comply with a framework that would essentially normalize their situation, including by registering the tokens under the 34 Act and offering a sort of a claims process to impacted investors. So we had many meetings, and Corp Fin attended Wells meetings, attended settlement discussions, and so really worked quite well with it. And I think that model is is going to continue.
Another big highlight this year was the SEC's case against Lou that went all the way up to the United States Supreme Court. On June 22nd, 2020, in Lou versus the SEC, the United States Supreme Court held in an 8-1 decision that a disgorgement award is equitable relief permissible under the SEC's investigative authority, and provided that three principles are met. One is that the disgorgement should benefit the wronged investors. Two, that the courts can hold parties liable for only their own profits. In other words, not the legitimate business expenses that these defendants incurred. And that the disgorgement really couldn't exceed the actual gain to the defendant here. In other words, it was disgorgement had to focus on the net profit as opposed to gross revenue of the wrongdoer. Andrew, I know that's an area of disgorgement that you focused on during your career as director and in private practice. Could you tell the audience what you think the impact of the Liu decision would be, and how you see it going forward with both on the defense side and the SEC?
Sure. I tend to think that probably everybody on this panel focused on disgorgement when they were director, but to answer your question, I think there's three aspects to what you said. I mean, in terms of the impact of the requirement that the disgorgement be for the benefit of investors, that obviously raises the question about whether, if the money is going to the Treasury, whether in fact you can get disgorgement in those circumstances. Obviously, many cases where that's not an issue, offering frauds, other types of Ponzi schemes, other things like that, where there are clear victims, those are going to be distributed out to the victims through a fair fund and through distributions, which Stephanie and Steve have talked about. But there are cases where it's a question as to whether you can identify victims. Insider trading cases are actually interesting area where the question is, are there particular victims of insider trading? There was always an issue about whether you distribute those. When I was a director, we did do a couple of insider trading cases when there was large amounts of money where we did do distributions, but those were actually few and far between. Most insider trading cases don't have distributions. So the question is, can you recover disgorgement there? FCPA cases, question is, you're not usually giving out the disgorgement to the victims. Does that create an issue? And so that's going to be an issue. I think, what we've seen in the last, since Liu, is the commission has continued, the division has continued to obtain disgorgement in those types of cases. So in settled cases, it doesn't seem to be disrupting things, but we'll see in litigated cases whether that's an issue. And I think ultimately that'll be decided potentially by the Supreme Court as to whether, when it's distributed to the Treasury, it's disgorgement that the commission can get. I think one of the things we've seen, and Stephanie and Steve foreshadowed this, I think after the decision came out, was that there are cases where the commission is going to get a higher penalty to reflect that they're not necessarily able to collect disgorgement in a particular case. And we've seen that where the penalty penalty demands have been heightened by the fact that you're not going to have a disgorgement piece. The truth is, penalties can be distributed as fair funds anyway, and so whether it's characterized as disgorgement or penalty, at the end of the day, doesn't really matter for the purpose of distribution. And so I think ultimately you're going to see that more and more. And in fact, in cases the staff has been overt about that. And I think, so you have a discussion about that, and, that's kind of the way it is. On the legitimate expense issue, I think that's actually very significant and will impact many cases, particularly FCPA type cases, but other cases. I think it does give the defense bar a hook to argue that those kinds of legitimate expenses should be deducted. There has been that debate for years, and there has always been, I think, some inclination on the staff to deduct expenses, but there's been a question about particular expenses, whether they were legitimate expenses. And I think this will give people a hook to argue that things like, for example, allocable overhead, potentially should render at the SEC out how they're looking at these things. And he talked about how the division is looking at what makes expenses legitimate. So it looks at things like, are these expenses consistent with the investor's understanding of what the permissible expenses would be absent fraud versus were they incurred specifically in connection with the violation. And so those types of questions are there. There'll obviously be cases where the whole enterprise was a fraud. And so the question there is, do you actually get to deduct expenses? Do you get to deduct taxes? Those kinds of things. So this will be an interesting issue. I think it'll play out case by case. I think there'll be some interesting decisions that will ultimately come out on this. And like everything with the decisions that come out that impacted the division's work, we'll see over time how it plays out.
Mm-hmm. Steve, how significant do you think Liu is going to be for the SEC? Is the SEC just going to increase the penalty side of the equation to make up for perhaps the lower disgorgement amount?
So I think, so in one respect, the division since Kokesh has been pursuing a disgorgement in a manner that in many respects is consistent with, sort of the strictures that were set forth in Liu. And that's not an accident. That was a deliberate strategy on Stephanie's and my part to be more restrained in the kind of disgorgement that we sought, with an idea that this would find its way back up before the Supreme Court. And I think, frankly, some of that restraint ended up working to the Commission's favor in the ultimate, affirmance of the disgorgement authority. So I think in that respect, taking, for example, the SEC hasn't sought disgorgement from remote tippies, from a tipper of funds that aren't in the tipper's possession for, certainly since, 2017 and maybe even before. And we've been, I think, open to the idea of legitimate expenses being deducted, et cetera. So I don't think there's going to be that, much of a sea change. But obviously, to the extent that the suggestion in lieu that money has to be returned to investors is a requirement for the disgorgement to be deemed an equitable remedy, in some kinds of cases, as Andrew points out, that's going to be difficult to do. What I don't see happening is I don't see insider traders paying, a one-time penalty, and not, disgorgement, because that would sort of incentivize people to insider trade, since all you have to do would be give back the profits if you get caught. So in those cases, I expect, increased penalties if a distribution isn't feasible. And we'll see how things play out in other cases like the FCPA. But I think it's a very significant decision. And at least through mid-August, I know it was something that the division and other places within the agency, including the General Counsel's office, were taking very, very seriously.
One of the another big area for the SEC this year was the earnings per share initiative. On September 28, 2020, the SEC announced its first actions against public companies arising from the EPS initiative, finding that those public companies used accounting adjustments to nudge their earnings per share and meet analyst expectations. Dick Walker, I know this is an area you and others have been very focused on. How should CFOs and CEOs be responding to these actions and the earnings per share initiative?
Well, thanks, Brad. I think it's interesting that this initiative, which was, I guess, previously unnamed as requests went out and issuers got, information requests. And I think Stephanie gave a very good speech at the University of Pennsylvania in September, where she sort of previewed these EPS cases and by announcing that there were going to be important changes in strategy and approach with respect to financial fraud investigations. And she outlined a number of factors that were going to be deployed. As she said, a quote, a variety of research, approaches, internal and external tools, and other information sets. And I think in looking at this, you can really see the clear impact of data analytics. So there was some academic literature, I think back in 2018, that was published that talked about anomalies in EPS reported numbers. And I don't think it took too much for the folks at the commission to, put together some programs to identify reported EPS for a broad swath of issuers, develop a program that would kick out the outliers. And I think that's what we saw in the first two cases. And I think some of the common themes that CFOs would want to be thinking about is situations where you have, periods where successive periods where you meet or exceed the estimates, and then all of a sudden, sort of you have to pay the piper, and EPS goes down. And I think those kinds of things kick out. You can readily see those. But in terms of advice to sort of get ready for this, I think one of the things that's what's very clear is the importance of controls, disclosure controls, having good, robust disclosure committees, so that when you're doing kind of manual, changes after the books close, which every company does, you make sure that there's a very rigorous process, so that it's not just a CFO or a CEO directing people to do things to make changes, but that there's a process that considers, changes that affect your EPS very, very carefully, and that is sufficiently documented. So I think those are going to be very, very important things going forward. I think the two cases that were brought, we saw some real, if you will, management manipulative activity, and I use manipulative in the small lowercase, but basically people telling others what to do. And in one case, I think there was a situation where there was, guidance. There were tools within the firm and policies and procedures, but the firm deviated. So sometimes they would follow the policy when it helped them, and other times they wouldn't when it didn't help. So if you've got the policies, you got to make sure that they're robust. And if there's going to be an exception to them, it's got to be pretty well documented.
Stephanie, besides the earnings per share area, is there any area where the SEC is focusing its data analytics in terms of market sweeps or self-reporting initiatives? Is there any guidance you can give us in terms of what's the road ahead?
Well, there are no self-reporting initiatives in the works right now. Sweeps, sort of harder to say, right? We may all differ on what a sweep is and what isn't. But I will say, just so there are other areas where we're using risk analytics to identify potential cases. And I guess I would point to a case we brought in the last month or so against Hilton Worldwide Holdings that related to perquisite disclosures. And in our release on that case, we made clear that that was also something that was identified through a risk analytic initiative. So there are other places where we're using these sorts of analytics to identify potential cases, but nothing in the way of a self-reporting initiative right now.
Stephanie, on this point, each year it seems as though we are discussing disclosure cases. For example, channel stuffing cases seem to be a constant theme of cases that the SEC has been bringing. This year, Diageo settled in action with the SEC for its involvement in channel stuffing distributors with excess alcohol and not disclosing how that inflated demand would impact future growth. And the SEC continues to seem to be focusing on these channel stuffing cases. Are you seeing any trends in these types of cases? How is the SEC approaching channel stuffing? Is this an area where you see greater emphasis from the SEC?
So interesting question as to whether we've seen trends, because this case and there are a few others we brought in the last year, sort of talk about disclosure in light of known trends. And so I'd pull this conversation back a bit from channel stuffing and talk about it more in the context of, the disclosure that we're looking at. And so Diageo is an example. I think probably the cases we brought in the last year against Marvell and HP probably also sort of fall in that category where I would say broadly, these are cases where we focused on the disclosure, where the pull-in practices can create a misleading or incomplete picture about the company's financial results, the company's ability to meet revenue targets. And without sort of, I don't think I would say anything about a trend on these types of cases as much as the overall importance of MD&A and related disclosure and sort of thinking about all these sorts of cases from a disclosure and accounting perspective. So to come back to where we started, no, I wouldn't say there's a trend, but I think I've also publicly been very clear that we've been incredibly focused on cases in the financial fraud and issuer disclosure space. And I would, point to these as really only a few examples of all the cases we've brought in this space in the last couple of years.
Linda, you were the enforcement director during the financial crisis, and from the financial crisis stemmed a number of investigations and enforcement actions relating to company disclosures. Do you see a number of cases in the pipeline now with COVID and COVID-related disclosures?
Well, I think what we can anticipate is that COVID has put all kinds of stressors on all kinds of companies. There are companies that are doing very well as a result. There are companies that are doing very poorly. And those stressors may manifest themselves in reporting issues. I think that's, we see that over and over and over again. One of the unique features of COVID, which is something that I'm sure everyone on this call and everyone in the audience is focused on, is by virtue of going remotely, that adds stressors to systems. So companies that have had historically perfectly wonderful systems of internal accounting controls, internal controls, checks and balances, those systems are operating differently. And the combination of having stresses on the business, positive and negative, as well as stresses on your systems because they're operating differently, I can anticipate issues coming up. It's just in the nature of things. How it will manifest, who knows? But I think it is in everyone's interest to be paying attention to that. And I'm quite confident the public accounting firms are focused on that because there are just so many differences that are going on. I mean, you look at a company that does deliveries, for example, their business may be way up. Who knows a couple months out whether they're going to be interested in smoothing earnings or trying to show a consistent trend. Companies that are suffering may be sure that it's temporary, and that will reflect itself in how things are accounted for. And while they may have had systems that would have caught that when you're in the office and people are interacting in person, it's not entirely clear how that's all going to be caught or managed in circumstances where the way people work has changed so much.
Mm-hmm. Some of the recent disclosure cases have been focused on revenue recognition and the danger of setting internal sales or revenue targets that could be relevant to this discussion about COVID. For instance, on August 25th, 2020, the SEC announced a settlement with Supermicro Computer Inc. for prematurely recognizing revenue and understating expenses in order to maximize the end of quarter revenue. I would go to Bill here. Bill, what are the lessons for companies in terms of managing internal financial controls and reporting? And what kind of advice would you give to companies in terms of setting internal revenue or sales targets in light of Supermicro Computer and what might be going on right now with COVID?
Yeah, I mean, look, this is as much an issue of culture and corporate governance as it is detailed policies and procedures and controls. You really have discipline where people understand that look, all companies have targets. There's pressure to deliver. Shareholders expect it. That's what management's hired for. The issue is in the company, in the C-suite, and in the boardroom is the governance culture such that you're going to demand performance with the appropriate bumpers and disciplines around. You can't fudge, you can't overreach, and you can't think that that's ultimately serving the shareholders and good governance. And that's really the mix, the balance. And having that atmosphere and that culture at the right level is a challenge all the time. It's particularly difficult when companies, industries, sectors are under stress. And I think that's really where the rubber meets the road. And it's where we may see in 6 months, a year, cases come out where people basically succumb to the effort to try to deliver, notwithstanding what the sales are or what the targets were. And you'll see some cases that will indicate that was something that transpired during this period.
We couldn't have a panel without talking about corporate penalties. Some call them shareholder penalties. Although the Division of Enforcement's 2020 annual report is not yet out, on October 8th, 2020, Bloomberg reported that the SEC has brought over 700 enforcement actions in fiscal year 2020. In comparison, the SEC brought over 850 in fiscal year 2019. And there seems to be, though, a shift in focus away from what have been traditionally these larger corporate penalty cases outside of the FCPA space. And in fact, I believe from my count, outside of the FCPA case, the largest issuer penalty has been somewhere in the neighborhood of 40 million.
Sorry, Brad, I need to interrupt you on that just to preserve my record, which is
go ahead.
The commission brought an action against Wells Fargo this year, $500 million penalty. Facebook, $100 million penalty. Valiant, $45 million penalty. There are others. So sorry to be defensive, but
no,
Just
sorry.
want to set the record.
Please. Well, Stephanie, I think the question is, though, on the penalty side, is it time that we create another penalty statement or dust off the old penalty statement from 2006? How are companies able to really assess what ultimately would be the penalty liability when it's facing an SEC investigation these days?
So sorry to jump in, Andrew, on your question for a second. I mean, I think, and you know, I don't jump in to sort of make the point that we've gotten record penalties and therefore that makes us effective. I think it's just important to make sure, you know, there's not a misperception out there that the commission's not been getting appropriate penalties in appropriate cases. But I think, look, if you're talking about the 2006 penalty statement, I mean, different commissioners view that differently and the weight of it differently. But the factors in it, I think it's fair to say, are the factors certainly we in enforcement consider and think about when we think about recommending a penalty. And, you know, I don't suffer from the illusion that someone in the defense bar can predict or a company can predict what, you know, the enforcement staff will try to seek in the way of a penalty recommendation. But I do think people do have a pretty good sense based on precedent, based on the nature of the conduct, based on the nature of the charges. So I don't think this is a black box that people are operating in, but I think they're fair questions. I don't know, Steve, if you have.
Yeah, I mean, I think what we told the staff was that it's an appropriate, the 2006 penalty guidance is an appropriate lodestar and framework to look at and to refer to when writing to the commission, you know, recommending a particular penalty. You know, it isn't there is no SEC sentencing guidelines that allows you to calculate up the penalty with precision. I think most sophisticated practitioners, when they get to the end of an investigation, you know, have a pretty good sense of the neighborhood in which the SEC is going to seek a penalty. It's obviously not perfect, but you know, I think that it's very, I can't remember a situation where, you know, somebody said, this feels like a $5 million case, and the staff said, no, it's a $500 million case or a $50 million case. There's no question there's disagreement, but I think people looking to, you know, history have a good sense of sort of where people are gonna shoot at. But perhaps others have a different view. Maybe I'm still in a state of delusion.
Bill, are you feel like you have pretty good transparency in terms of where the staff's going to come out in terms of a penalty?
I'm always nervous, and I always start in a neighborhood that's much more moderately priced. Usually, I'm somewhat taken aback by not all cases, and I don't think guidelines, the equivalent of sentencing guidelines, would work. Look, $10 million used to be a lot of money. Today, when you're talking about a solution or a settlement in an SEC case, it's, you know, people approach it as though it's nothing. And it's just the reality of the world we live in. It's very hard, other than the feel you get from the way the government views the conduct, the impact, and how egregious it is, to figure out where you're going to land. The only thing you should assume is you probably ought to add a 0 or 2 to whatever you're thinking, because there's an inflation process at work here, and it is what it is.
You know, just one reaction to that, which is, I continue to believe that the penalty levels that the commission, you know, doles out are fractional compared to a standard DOJ case. You know, it's just you just don't see the commission seeking penalties that are, would get most federal prosecutors out of bed.
That's not a particularly comforting standard.
Yeah,
against
they
which to
probably
measure
should be,
yourself.
Steve. I mean, because that's criminal violation, right? Versus an SEC. So I hope that's where it sticks, right?
Dick, do you think the penalties have become more manageable under this administration in terms of the numbers, or do you think things continue to be the high penalty numbers of prior administrations?
I think there have been times where there was significant upward pressure to whatever the number was to raise it, and I think that was very publicly the policy of the division at different times. I don't think that's the policy today. I do think that precedent serves us better today than at some points in the past. And you can, I think, I don't know quite who said it, but if you look at the precedents of similar types of cases, you should get a pretty good feel of the range. And if it's more egregious, obviously it's going to be higher, but I think it's a good ballpark.
Just one last thing. I don't think you could get a penalty statement like 2006 through a current commission. I don't know what happened in 2006 that you got such a statement from all 5 commissioners, but I don't know how you get it in this current commission.
Why is that? Because it's too divisive, you think? Or
I just think different commissioners, as Stephanie said, have different views, and they're not going to ultimately, I think, necessarily agree on kind of the same perspective on it. And I think that as I think Stephanie said, like those factors are the factors. That's what you look to. They're out there. People look at them in every case, and that's, I think, the way it's going to continue.
Sure. Stephanie, as the director, you always get the final word. Anything to add to any of the points that we've been discussing?
Nope, I don't think I have anything more to add, Brad. Thank you.
Terrific.
Well, thank you, Stephanie. Thank you, Brad, and thank you to the whole panel of former directors. It's truly always special to get this group together, and really appreciate it. Our next panel on insider trading will begin at 1:40 p.m. We'll see you in just a minute.
Thank you.
Thank you.
Thank you.